an invitation to address this meeting. Really, I took it as a warrant instead of a summons. That is why I am now before you. The year 2023 and 24 are very important as far as lawyers are concerned. Our 1.5 century old criminal law has been changed. It is not changed, but it has been modified. Criminal law of a country reflects the culture, civilization, way of life. For example, a criminal law of a theological state, what would be the heinous offense? Not the murder or robbery or dacoity, but blasphemy. Blasphemy, madanindiyana, the very heinous offense. Insofar as the great Bharat India is concerned, our heinous offense is an offense against the human life. Before the advent of the political society, the responsibility to save one's life is vested with him, not to the political authority. After formation of this political institutions, the whole scenario has been changed. It is the duty of the state to protect oneself. Any offense will be an offense against the state, not an offense against an individual. So we are all concerned, as far as the lawyers are concerned, just to see our national scenario, every issue is politically oriented, legally oriented. So we, the lawyers, will have a role. We have a say on each and every issue. If you are taking the history of the world, the lawyers played a very vital role. In the history of US, the American Revolution was led by eminent lawyers, John Adams, Thomas Jefferson, George Washington, all lawyers. Even the Civil War led by lawyers, Abraham Lincoln, Martin Luther King and all. Even in the French Revolution, 3/4 of the Revolutionary Council composed of lawyers, Dabesbury, Dante and all. Even the V.A. Lenin was also a non-practicing lawyer. When we are coming to national scenario, India, Mahatma Gandhi, Pandit Jawaharlal Nehru, Motilal Nehru, all lawyers. Even now, just to see when reading the newspaper, we the lawyers will have a space in every issue. So the responsibility of the lawyers are very high. These 3 laws enacted by Parliament in the absence of opposition members, they were all suspended. It reflects everything, how this law is constitutionally valid. I don't know how far the political leaders voiced against the way in which this criminal law was enacted. So what is the law? Bharatiya Nyaya Sanhita. Bharatiya Nagarik Suraksha Sanhita. Bharati Sakshya Adhinaya. These are all Hindi words. I would say the very nomenclature itself is unconstitutional. I had occasion to address so many meetings on this new law. Unfortunately, our judges are not here. Many judges told me that, Mr. Asaf, what you said is correct. We, the sitting judges, may not be able to air our views. How we can say it is unconstitutional? a law enacted by Parliament and the Legislative Assembly, the nomenclature be in Hindi? No. Our Constitution prohibits. Just to read Article 348. Language to be used in the Supreme Court and High Courts and for acts, bills, etc. Notwithstanding anything in the foregoing provisions of this part, until Parliament law otherwise provides, all proceedings of the Supreme Court and every High Court, the authoritative text of all bills to be introduced or amendment thereto moved either in the House of Parliament or in the House of either of the House of Legislature, all acts passed by Parliament or the Legislature of State, all ordinance promulgated by President or Governor shall be in English. So I would say the very nomenclature itself is unconstitutional.
But nobody questioned them in the Parliament.
Does it mean that you can legalize? We are all observing a deceptive silence. You follow? And see, Bharatiya Nagarik Suraksha Sanhita. The objects, Bharatiya Nagarik Suraksha Sanhita, preamble, I am reading preamble. An act to consolidate and amend law relating to criminal procedure. An act to consolidate and amend law relating to criminal procedure. CRPC 1973 is not a colonial piece of legislation. In 1973 we revamped. And what is the preamble of CRPC? An act to consolidate amend law relating to criminal procedure. What is the name? Bharatiya Nagarik Suraksha Sanhita, Indian Citizen Protection Code. What is the difference? What is the similarity of this Bharatiya Nagarik Suraksha Sanhita? In Calicut there is a Maidanam, Modala Kolam. Avada Modale illa Kolavilla. This is only a procedural law. Is it not so? But the nomenclature is Indian Citizen Protection Code, which contains all non-protective provisions. Not all, most of them. I may be wrong, you can correct if I am going wrong. Every members who participate in this deliberation have got every right to question amidst my lecture. See, our Constitution contains a provision, Article 13, subclause 2. The Parliament cannot make any law in derogations of the provisions of the fundamental rights. That is the basic of our Indian Constitution. If there is a fundamental right, the Parliament or Legislative Assembly has no power to any act in derogations of the provisions of the fundamental rights. This Bharatiya Nagarik Suraksha Sanhita contains a provision 43.3. What is 43.3? The first time in the history of India, not even during the period of Britishers, the handcuff was not legalized. The Supreme Court in Katinoff decisions would say, you should not handcuff. You have no right to handcuff. If the accused is a violent in nature, if there is a compelling circumstances you to handcuff, you obtain the permission of the court. But what is the Bharatiya Nagarik Suraksha Sanhita would say? Police officer may keep, in view the nature and gravity of the offence, use handcuff. This provision is not in the colonial legislation of CRPC 1869. while making the arrest of a person, while producing such a person before the court who is habitual, I can understand he is an habitual offender, he is a violent nature, he is creating problems on the way to court and back. The Supreme Court said, you obtain the permission of the courts, then only you can handcuff. But here who is the category? Repeat offender. The repeat offender is not defined. When these two provisions, who is repeat offender? Ara, repeat offender, nature, we divasana patram vaayikunnalla. ഒരു റിപ്പീറ്റ് ഒഫൻഡർ ആരാണ്? 60 കേസ് 70 കേസിലുള്ള ആളുകൾ ആരാ? Our candidates, our whole candidates are repeat offenders. You just see the election affidavit, they are all involved in, did not say the repeat offender involved in dacoity, robbery, murder, etc. No. Simply said repeat offender, then you can very well handcuff him on the way to court. The first I said 2 points, unconstitutional. This was questioned one chief minister in India. Siddaramaiah sent a letter to Amit Shah. I got a copy. Respected Amit Shah ji, there are so many other things I will discuss. Opinion suggestions of the state of Karnataka on Bharatiya Nyaya Sanhita Bill 2023, Bharatiya Nagari Suraksha Sanhita Bill 2023 and the Bharatiya Sakya Adhinibayam Bill 2023. This was written on 26/10/2023 when the bill was first presented in Parliament. And he would say, just we discussed, the title of the bill gives an impression that it is meant for the safety of citizens, whereas it deals with the procedure for investigation and inquiry, trial, etc. of crimes. Is it not correct? What we have just now discussed as written by Siddaramaiah in a letter written to Amit Shah. And again he would say, he had made some suggestions also. And he has also pointed out, as per the mandate of Article 348 of the Constitution, the names of law should be in English, however the bills are in Hindi words. So just to see, my dear friends, a law enacted by Parliament in the absence of the opposition members, totally against the very basic nature of the constitutional provisions. And even the nomenclature itself is, the contents of the law is against the spirit of the nomenclature. That is what I would say. And what is the judgment of the Supreme Court? If the Supreme Court rendered a judgment on a particular point, that is the law of the land under Article 141, what the Supreme Court would say, in the celebrated judgment Sunil Batra and Delhi administration rendered by Justice Krishnaiyer, Pray Shamshankar Shukla, repeat offender is not defined in the provision. And Sunil Batra, the Supreme Court would say, 78 Supreme Court 1675, minimum freedom of movement which even an under trial cannot be cut down cruelly by application of handcuffs, other hoops, indiscriminate resorts to handcuffs when accused persons are taken to and from court, and the expedient forcing irons on prison inmates are illegal. That is what Supreme Court would say, and shall be stopped forthwith save in a small category of cases. Reckless handcuffing and chaining in public degrades. The Constitution guarantees the right to live with dignity. In Calicut, 6 months back, some students agitated. They were taken to court by putting them handcuffs. And recently, and Supreme Court, guidelines have been issued. In the strongest words, Supreme Court declared this. We declare, direct and lay down a rule that handcuffs or other fetters shall not be forced once a prisoner, convicted or under trial while lodged in a jail anywhere in the country or while transporting or in transit from one jail to another or from jail to court and back. The police and jail authorities on their own shall have no authority. The Supreme Court would say no authority to direct the handcuffing or any inmates of jail or another from jail to court and back. But the police or jail authorities have well-grounded basis. Suppose a prisoner is a violent nature, drawing a strong inference that a particular prisoner is like to jump jail or break out the custody before the magistrate concerned, and prayer for permission to handcuff prisoner be made before the magistrate. So there are safeguards. If the accused or a prisoner is in a violent nature, there are every chances of jumping out from custody. There is a provision in the directives issued by Supreme Court. If that is so, can you make a law against the directives of the Supreme Court, that too relating to fundamental rights? And recently, State of Maharashtra was Revigans in 1991. Bombay High Court held the Inspector of Police is responsible for a violation of Article 21 of the Constitution, ordering him to pay rupees 10,000 as compensation for having put the handcuffs illegally in violations of the directives of the Supreme Court. Again, Karnataka High Court recently in 2023 awarded compensation to the petitioner for unlawful handcuffing by the respondent contrary to the Supreme Court ruling. And 2012, Madurai bench of Madras High Court penalized 2 police constables to pay rupees 5,000 for handcuffing a detainee without getting the magistrate approval. So this is the law of the land. The judgment of the Supreme Court or the directive of the Supreme Court is the law of the land, that too relating to fundamental right provided under Article 21. If that is so, any law enacted by Parliament or Legislative Assembly is null and void to the extent of the directive or the fundamental right, Article 13(2), subclause 2 of the Constitution. That is what I would say. And next, very interesting, I am only highlighting some important provisions because I've got time only 1.5 hours, and we can have a deliberation, an interactive session or 30 minutes if permits. Trial in absentia. If an accused person is a proclaimed offender, the trial can proceed. Recently I had occasion to talk with one of the eminent persons of the government. I simply asked him, why are we not starting the trial of our Chako in Sukumara Kurpu case? Accused? No accused is necessary here. You can complete. Then he was a lawyer also. I am not mentioning the name. That is what the Section 356 of the Bharatic Nagarik Suraksha Sanhita would say. You can have a trial in absentia. There are some countries where the trial in absentia is permitted, in Australia, Italy and all. Even those countries also, there are some safeguards in favor of the accused. In a criminal trial, who is the main role to play? A Hamlet without Hamlet. How can I stage a Hamlet story, drama, without Hamlet? The main star of a criminal trial is none other than the accused. Your accused is nowhere. If he is proclaimed offender after 90 days, or new Nagarik Suraksha Sanhita would say you can proceed with the trial. What about the framing charge? Not necessary. And the law would say an advocate will be engaged by court. How an advocate will get instruction from accused? Without getting instruction from accused, how can he defend an accused? And after completion of the trial in 313, accused, just like a Tempest, Shakespeare's Tempest, there is a character. You must have learned Prospero. The character is invisible. Prospero will be everywhere, but it is invisible. After trial, the 313 will be completed. How? You can proceed. That is what law says. And after completing the trial, if the accused is found guilty under 302, questioning the accused on sentence in absentia, and he is found guilty and awarded capital punishments, that too in absentia. And after 3 years of the pronouncement of the judgment, you have no right to appeal. You have no right to appeal. We are not heard. It is not against the basic structure of the Constitution. No one shall be condemned unheard. That is what I would say, how the lawmakers applied their wisdom in enacting a law like this to be thrown into basket, with due respect to the lawmakers of the Delhi. Where the proclaimed offender is not represented by advocate, he shall be provided with the advocate. How the advocate will get instruction from heaven or hell, no idea. Where the court competent to try the case or committed the trial has examined any witnesses for prosecution, recorded their deposition, such deposition shall be given evidence against such a proclaimed offender. The trial will be there. Examination of witness 356(5). May, as far as particle recorded by audio, video, electronics means, I will explain it later. If such person absents during trial to continue till pronouncing judgment, even if he is arrested and produced or appears in court, leave it. No appeal against such a judgment unless proclaimed upon presence himself before the appellate court. If he is found guilty and sentenced to undergo life imprisonment or capital punishment, he can file appeal only in person, not in absentia. That too after 3 years, he will be deprived of his right to file an appeal. If a person is involved in a 302, he is tried for an offence under 302, he will be convicted without hearing him on framing of charge, without questioning him on 313, Rustable 313, and without questioning him on sentence, he is awarded capital punishment, and he has no other remedy but to face the slap of the punishment provided under 356. If that is so, at the very outset, one thing we must remember, there must be a fair trial. It is our fundamental right. For a fair trial, if the accused is present, okay. If he is not in a position to engage a lawyer, the court can provide a lawyer, legal service authority. But the accused is nowhere. The provision would say the court will provide him the assistance of a lawyer. What the lawyer can do? How can the lawyer cross-examine the witness without getting instruction from party? There are provisions after when he is proclaimed offender, there will be notification in the newspaper and it will be affixed on his house, etc., etc. So these are all totally illegal, unconstitutional. It is totally against the fundamental right guaranteed by the Constitution of India. You must have majority, you can make. Our country is not a majoritarian country. Justice National Judicial Appointment Commission Bill, it was passed by Parliament, mooted by BJP, supported by Congress, CPIM, CPM, and all political parties, unanimously enacted. And the subject matter involved in the 99th Constitutional Amendment Bill relating to court and judiciary, it is to be ratified by half of the legislative assemblies. 20 assemblies ratified that bill. What happened? The Supreme Court declared it null and void, unconstitutional. It was enacted by Parliament unanimously, ratified by the 20 legislative assemblies. That provision is now not in the statutes. So that is what I would say. Then you may ask, our constitution starts with the we the people. We the people enacted a law. What is the job of, what is the authority of the court? The very same question asked Mr. Palkiwala during the course of hearing in Keshavananda Bharati case. One Justice Dwivedi asked Palkiwala, Mr. Palkiwala, you see, do you think that the Parliament has no authority to enact a law? You have got some limitations. Palkiwala simply asked, the Parliament passed in A.K. Gopalan's case, that was the case first raised, but the Supreme Court did not accept. A.K. Gopalan was arrested, procedure established by law. What is procedure established by law? A law enacted by Parliament or Legislative Assembly is called procedure established by law. No person shall be deprived of his life or liberty except in accordance with the procedure established by law. Then when Mr. M.K. Zabir, the father of our former Attorney General K.K. Venugopal, asked, what do you mean by procedure established by law, law enacted by Parliament? If the Parliament enacts a law that all the opposition members shall be put in jail for a period of 50 years in the preventive detention, naturally it will be enacted. Then do you think that it is legally valid? Supreme Court, the wisdom did not dawn on the head of the Supreme Court. After 28 years in Maneka Gandhi case, Supreme Court said, we have committed a blunder 28 years ago, we are correcting it. The very same question asked Mr. Palkiwala in 1973. Palkiwala simply asked, we got a constitution which contains a provision, Article 368, the amending provision, which means amending provision. If I am making a statue and written underneath, it can be amended. Does it mean that it can remodel? You can make some amendments. You can make some constitutional amendments. That alone. In again, other side, there is a provision, zero FIR. I would say it is really a revolutionary piece of provision contained in the Bharati Nagari Suraksha Sanhita. Zero FIR. If an offence is committed in Italy, as per the pre-amended law, if that offence is if the crime is an offence in India, if it is committed outside India, as per 198, etc., as per section 4 of the IPC, an FIR can be registered, he can be tried here in India, provided you have to obtain a sanction from the government of India. Joseph is first found. Then we, the advocate, used to say, when we are coming from Alapi, I found the accused running then the LLP court has got jurisdiction. But in this act, in this provision, section 173, every information relating to the commission of a cognizable, irrespective of the area where the offence is committed. Only an information alone is sufficient. That is a very revolutionary legislation, I would say. And there are some other provisions if it is electronically, etc. But again, the ball goes to the hands of police. What the Supreme Court in so many judgments will say as per the Rustable 154, an information relating to commission of a cognizable offence, the police shall register a FIR. Police shall. As per the British-made CRPC 8069 law, when the police gets a complaint, when it amended in 73, it is an information. But unfortunately here, the ball gets to the police. If the offence is punishable for 7 years, police is not bound to register an FIR unless a preliminary inquiry is conducted. അതിൻ്റെ അർത്ഥം എന്താണ്? പോലീസിൻ്റെ കീശയിൽ പണം എത്തിയാൽ മാത്രമേ FIR വെളിച്ചം കാണുകയുള്ളൂ. Totally rubbish. To get an FIR registered is my right. In 2011 Kerala Police Act, there was a provision earlier in the bill, just like a provision like this, to conduct a preliminary inquiry before registration of FIR. We, the members of Lawyers Congress, shouted. We conducted so many police reforms meetings, etc. In the Parliamentary Legislative, Assembly Legislative Committee made a sitting in Kannur. And the Home Minister, Kodiyeri Balakrishnan, telephoned me and said, Mr. Asaf, you must come. I mean, sir, I am against this draft bill. We want your controversion. That is what I am inviting you. I attended the meeting. I presented my case that the preliminary inquiry will spoil the situation. That is what, in that bill, there was a provision before registration of an FIR, a preliminary inquiry is to be conducted. Just to see 173(3). Without prejudice to the provisions contained in section 175, on receipt of information relating to the commission of a cognizable offence which is made punishable for 3 years or more but less than 7 years. 3 years or more, almost all offences are 3 years or more and less than 7 years. Officer in charge of police station may, with prior permission from the officer in charge of police station may, with prior permission from an officer not below the rank of a deputy chief, must consider the nature and gravity of the offence, proceed to conduct a preliminary inquiry to ascertain whether there exists any prima facie case for proceeding. Just to see, my dear friends, if there is an offence committed, police get the information. What prevents the police from not registering the FIR then and there? Is it not my duty to see the culprit is booked? After registering an FIR and conducting an investigation or inquiry, you can close, you can refer, we don't care. But my right to get punished the culprit has been curtailed here. Is it not against the spirit of Constitution? To book the culprit, have a fair trial, is it not my right? If this right given to the police, what they will do? They will have to get to the dicta of their masters. They will decide whether an FIR is to be registered or not. That is what I would say. The preliminary inquiry before registration FIR as contained in the 173(3) is totally against the spirit of the code. Again, we, the members of bar, we are fully aware. In civil side, if you are filing an injunction suit and getting it temporary injunction, you will have a satisfaction. If in criminal say, if you are filing a private complaint and taking cognizance by the magistrate, you will have a satisfaction. Sometimes the case may end in settlement. Here, a provision has been incorporated. But after recording sworn statement, the magistrate will have to hear a prospective accused. Have you heard of it? That is what I would say, 175. The magistrate power of investigation, magistrate power to take cognizance has been curtailed, I would say. Any magistrate empowered under section 2.1 new, after considering the application supported by an affidavit, after making such inquiry as he thinks necessary, submission made in this regard to the police officer or such other investigation, and if a public servant files a complaint against an ordinary man, no problem, magistrate can simply issue summons. But an ordinary man files a complaint against a public servant, then magistrate cannot. The power of magistrate has been curtailed. So what our constitution would say, equality before law, equal protection of law. Here, when a public servant, that is what we would say, any magistrate, a complaint is filed against a public servant. Public servant, you know, in vigilance prevention of corruption cases, all the corrupt officials, against all corrupt officials, we are rushing to court with a private complaint after exhausting all remedies. Because when we are filing a complaint to vigilance, they will say we have to conduct a preliminary inquiry. In PC Act, even otherwise, there must be a preliminary inquiry. That remedy is exhausted, and we are rushing to court, special court, against a public servant, or before a magistrate court against a police official who has done some cruelty, some atrocity, some torture in custody. Then what is the thing? The magistrate has no power straight away issue summons. Any magistrate empowered under section 210 may, after considering the application supported by affidavit, and after making such inquiry as he thinks fit, submission made in this regard, police officer order such investigation as above. Nowadays, we can very well get it, a complaint investigated by police 156.3. Any magistrate empowered under 210 may, upon receiving against a public servant arising cause of discharge of his official duty, investigation, order investigation. Magistrate can order investigation only under two conditions. What is the condition? Receiving a report containing facts and circumstances of the incident from the officer superior to him. One police officer committed some atrocity against an innocent man. I am filing a complaint before magistrate because I cannot approach police, because police will never register a case. Then the magistrate, after conducting a preliminary inquiry, even if the magistrate is satisfied that there are prima facie case made out against the accused, prospective accused, prior to the amendment, the magistrate can very well issue summons to the accused. Here, as per amendment, magistrate will have to call for a report from the superior of that prospective accused. ഒരു പോലീസുകാരൻ തോന്നിയാസം ചെയ്താൽ SP യോട് അല്ലെ CA യോട് റിപ്പോർട്ട് ചോദിക്കണം. Just imagine what would be the contents of the report. And after considering the assertion made the public servant, ആ പ്രതിയുടെ assertion കേൾക്കണം. Is it not a matter of impossibility, legal impossibility? So what is the ultimate result? There will be a police atrocities. Is it Suraksha Sannidha? What Siddharamaya said is perfectly correct. Is it not perfectly correct? The code contains a provision that the police officer, even if he commits a murder, the police will never register an FIR. We can approach magistrate. We are examining the witness. We are examining the doctor who conducted the postmortem. Then the code would say a report is to be called for from the superior officer. That we can understand. Again, an assertion from the accused, public servant. Just imagine what would be the results. I would say this is a code which curtailed the right of an innocent man who is likely to be victimized by the hands of cruel police official or a public servant. Because the code provided a provision that before proceeding against that prospective accused, his assertion is to be called for. A robbery നടത്തിയ ഒരാളോട് you just see your assertion about the alleged incident, what would be the results? Again, 223. What is 223? Ordinary private complaint. We are filing. Then we are examining the complainant, witnesses, and my case is that a robbery or a dacoity. I tendered all evidence. The magistrate was totally satisfied. Then the code would say, provided that no cognizance of an offence shall be taken by the magistrate, without giving the accused an opportunity of being heard. Here, accused ennu ubhayogikane paadilla, because he is not accused at that point of time. Only after taking cognizance of offence, he will be called as accused. Here, I would say, he is a prospective accused. That is what the words used, the terms used in the statute is totally unheard. Because he is not an accused. How a person becomes an accused? Only after taking cognizance of offence against him. The code would say, before taking cognizance, he is to be heard. He can be heard. Then what would be the result? Cognizance taken. He will get an opportunity to go up to Supreme Court. By the time, what would be the fate of an ordinary victim who is subjected to dacoity, who is subjected to robbery, who is subjected to theft or etc. So that is what I would say, we the members of the bar. These are all unworkable provisions. It is totally against the spirit of the Constitution. It is totally against our fundamental right to live, right to move freely, right to exercise our personal liberty. Then there are some provisions. So that is what I would say. The provisions regarding the private complaint incorporated in this new code is totally against the law and unconstitutional. In that point of view, it is unconstitutional. If a superior officer submits a report, the magistrate will believe whose version? Naturally, the superior officer will whitewash the culprit and say that he is totally innocent. Then the magistrate will be put in deep trouble. And if an order is passed against the complainant in favor of the prospective accused, the innocent victim will have to approach the appellate court, high court and Supreme Court at whose expense? He is already a victim, subjected to a criminal act by a police official using the government machinery. Then he is not in a position to approach. That is what I would say. We are not in a position to knock the door of judges, knock the door of judiciary court, because there are fetters on our hands. Again, some provision with regard to search and seizure, but it is not even now implemented. That is what I would say. Search and seizure through audio, video, electronics means. That is a very, very important provision. 105. Because normally the police used to prepare, they collect some material from the crime scene and everything will be prepared from their house or any other tea shop or police station everywhere, which will be very prejudicial to the victim, and sometimes it will be very prejudicial to the accused. Because sometimes the accused was not even present. The witnesses, those who were who certified, who attested the murder, need not necessarily be there present at the time when they prepared the list. He will be somewhere in hospital or some train journey, etc., etc. But that provision, recording search and seizure through audio, video, electronics, process of conducting search of a place taking possession of any property, article or thing under chapter 185, section 19, including preparation of list of thing. But here, the state government has got the burden duty to provide all the provisions. I just collected some financial burden. There can be the minimum number of audio video recorded at a police station at some minimum ratio is, say, 5 recorders per police station. Considering 5 IOs at simultaneous work, this will be needed till the state migrates fully in e-Akshaya facility. And one dedicated desktop for evidence specialist, data manager, information asset, etc. Not a single police station, these are all not made. No provision for these things. There is a provision, but that is what once Palkiwala said, we have too many laws, too little justice. This is a very good provision, but who will implement it? This is to be implemented by state government. And time limit for submitting the charge sheet, etc. is good. Nowadays, indefinite, especially in POXO cases and rape cases and offense against women, the provision has been incorporated in the new Nyaya Sanhita, Nagari Suraksha Sanhita, a time limit for completing investigation. Again, now we are all talking about the ED's powers, Enforcement Directorate. Our police got and magistrate got that much power as per the new Nagari Suraksha Sanhita. If a police officer seizes a property which is said to be a proceeds of crime, now only after final judgment that can be disposed of. Now as per 107, the court has got every power, attachment, restoration and disposal. Just like a PMLA Act, Prevention of Money Laundering Act. That provision has been incorporated in the new law, 107. Where a police officer making an investigation has reason to believe that any property is derived or obtained directly or indirectly, these are all words of the PMLA Act, proceeds of crime. Obtained directly or indirectly as a result of a criminal activity or from the commission of an offence. He may, with the approval of the Superintendent of Police or Commissioner of Police, make an application to court. The magistrate exercising jurisdiction to take cognizance of the offence, commit for trial, for attachment of the, if the court or the magistrate reason to believe whether before or after taking evidence, before or after taking evidence, even before trial, all or any of such properties are proceeds of crime, the court or the magistrate may issue notice upon such a person, calling upon him to show cause within a period of 14 days and order an attachment. Why an order shall not be attached? And proceeds of crime has also been defined under 111 in the Nagari Suraksha Sanhita. That is, according to me, there are very chances of misuse and abuse. Because if the accused is found not guilty and exonerated from charges, what would be the fate of these properties? A question to be decided. Again, another provision, just like we discussed about an offence committed outside India.